we will begin with a focus on employment and immigration topics, and how to ensure a smooth HR international onboarding in terms of employment law and immigration compliance. Before going further, I want to make sure, do you hear me well? The sound is fine? Yes?
Yes.
Okay.
Yes.
Okay. So next slide, please, Sam. In a very few words, because we made a very quick introduction previously, but I'm not the only one within the firm. So Majorel Conseil is a group of expertise, and we offer companies efficient legal, human, and organizational support for all HR projects. So we have the law firm, Majorel Avocat, dedicated to employment law topics. We have got Majorel RH, dedicated to HR organizational transformation and challenges. Majorel Executive, to hire executive position within your companies. And finally, Majorel Mobility. Next slide, please, Sam, to present Majorel Mobility. So within Majorel Mobility, we are all lawyers too, and we are only dedicated to international mobility topics, business immigration, the regulation of posting workers, what we call the secondment also of foreign employees to France. And more generally speaking, we assist foreign companies with a full range of employment law and social security law regulation. We can go to next slide to go in the details. So yeah, some introductory words. Of course, international mobility of workers is a big challenge, a rapidly expanding phenomenon. We see that the numbers of workers being traveling and working abroad is increasing each year. And especially between France and the UK, the topic is more complex, of course, since the Brexit. Um, we still see that some companies have not yet taken the update of the post-COVID regulation, post-Brexit regulation. So now British employees need visa to work in France, they need work permits, and their companies must comply with all the employment law, social security law, immigration regulation in France. So it's not always easy to monitor this, to be in compliance. And of course, international mobility is very linked to the global diplomatic, economic, political scenes, as we can see with what happens with the Trump administration or Ukraine and Russia, whatever. All of this generates a lot of, raises a lot of questions and problematics to solve. And international mobility, as we will see, is a niche legal topic because there is in France no specific law that was designed to deal on the same level at the same time all mandatory topics such as employment law, social security, tax, immigration, or even insurance. So we need to work on all those topics and make them match together to ensure compliance. We can go to next slide, please, Sam. Thank you. And next one also. Yes, so to make sure that we are talking about the same key notions, when you are talking with a French lawyer, a French HR manager, a French company, we will often use the same definition, the same terminology. And it's very important to get to know it because otherwise you always, we hear people talking about, he is an expatriate, he is seconded, he's with a local contract, but we don't know exactly what is behind. So in terms of labor law, the secondment refers to an employee working abroad temporarily and remaining under the authority of the original company. So in our case, an employee of a British company being sent temporarily in France, for instance, for 3 months. Okay. On the contrary, an expatriate is an employee whose original employment contract is suspended and who enters into a new employment relationship abroad, so in France. And finally, localization, it means that the original British employment contract is terminated, is over, and we only have a French employment contract. So it means that there is no remaining suspended British employment contract. So it's very important to have this definition in mind because in social security law, the same word doesn't mean the same thing, which is beautiful in terms of French regulation. In social security law, the principle is that you need to pay your contributions in the country where you work. So being an expatriate means that you will be affiliated within the social security system of the new country in France. If you are a British employee working in France, you are expatriate and you need to pay your contributions in France. This is true unless you have got a specific regulation enabling you to remain affiliated to your original social security system. And this is a secondment scheme. Being a seconded employee means that you can remain under your British social security system for a while, at least, while working in France. And after that, we have specific case of cross-border workers, but we will not see it in detail this morning. And finally, we have got all those tax law regulation. So the question is where an employee needs to pay the income tax, in which country, in UK or in France. And in tax, under the French tax regulation, you don't have this definition of being an expatriate or a seconded person. You are either a British tax resident or a French tax resident, and you don't have really the choice because we have got some very strict definition enabling us to determine in which country you are. We can go to next slide, please, Sam. So I tried to summarize all topics in a nice, colorful chart. To ensure global compliance, the methodology we often use is to start with immigration, because immigration has been so challenging these last years that we know that the immigration answer will have consequences for labor rules, social protection, and sometimes also tax. So first, we need to assess which type of visa work permits we need to apply for, because it will have direct impact in terms of cost, delays, and global mobility scheme. It involves both the companies and the worker. So often they need to work together to make sure that immigration is compliant. In terms of labor rules, we always need to determine if the UK or the French labor rules will apply, in which case, if we are in a remote situation, an intra-group mobility situation, or a service providing agreements, not the same employment rules will apply in terms of minimum wage, working conditions, working time, etc. Then social protection, but my colleague will talk about it later, but it is very important to contribute for health scheme, retirement, disability, and employment fund, of course. And finally, tax compliance. Tax compliance we have two very important aspects. It's the workers' tax residency transfer, okay, income tax problem issue, and sometimes a corporate tax issue, especially if the foreign company is recognized in France as being taxable. We called it the PE recognition, permanent establishment. We can go to next slide, please, Sam. And with international mobility of workers, we have basically two main options. So I try to summarize this. So with option A, we consider that UK workers are seconded in France. In option B, they are localized. So in option A, it means that the British worker is temporarily assigned to work in a subsidiary in France while remaining employed by the home company. So it refers mostly to intra-group mobility situation. So for instance, I don't know, a UK company has got a subsidiary in France and they just post their UK workers in France for 6 months. This is a secondment. And we can use also this scheme for subcontracting or service provision agreement when UK workers are posted through the client's legal entity. In option B, on the contrary, the employee ceases to be employed by the home company and signs a local contract with the host entity in France. And in such a situation, we refer to either direct hiring with a French legal entity. For instance, we we cannot be a posted worker anymore because the duration has been exceeded. So we need to localize people in France. Or sometimes it's just because posting is not feasible because the criteria are not met or no longer met, for instance. And sometimes we need to use what we call the non-employer of record solution. It refers to the case where a UK company does not have any uh, legal entity in France and no clients in France being able to welcome your workers. So sometimes we need to use what we call the NEOR. We can go to next slide, Sam, please. So what are the consequences of those big, no, sorry, the, yeah, yes, thank you, Sam, thank you. Um, what are the legal consequences of those two choices, option A and option B? So in option A, the legal consequences are the following. With the employment contract, the British original contract remains in force. So we still apply UK laws. So in terms of HR management, it means that you keep what you know very well, the UK regulation. It's for short durations, usually 6 months, 1 year, maybe 2 years. The reporting line is still with the home employer, and the social security remains very often in the UK. Not always, but very often. In terms of option B, the change is major because you will have a French employment contract. So it means that you need to know how the French law applies and the collective bargaining agreements too. In terms of duration, it can be open-ended duration. The reporting line is within the host company in France, and very frequently, the social security affiliation will be in France. So as you can see, the two options are very different in terms of social compliance. So it's very important to ask the good question at the beginning of your project. Am I in a short-term assignment or long-term assignment within a client or within the French subsidiary of my group to determine what to do next? Okay, Sam, we can go to the immigration topic. I will try to be quick because I know that my my colleagues have also a lot of things to tell you. In terms of French immigration landscape, basically, we see that the French immigration is being more and more strict every year. So the requirements to get the visas, work permits, residence card are high, and the standards are quite difficult to get. So what we do, it's always the same way to proceed. First, we analyze the situation of the workers to get an immigration strategy. Then we ask our clients to get all documentation to fill the visa application, the work permits application. Then hopefully the worker arrives in France and is compliant and can work. And finally, we ensure HR monitoring in the long term because it's not because your worker is in France that in 2 years or 5 years he will still be compliant. So it's very important to keep an eye on them while they are working in France. So in France, we have basically either short-term visa or long-term visa. And we have a full range of visas depending on what you are going to do in France. The level of remuneration you will have, the educational background, professional background, all of this will determine which type of visa and residence card you will get. And of course, we have this talent category, which is very favorable to foreign workers in France because it allows them to stay longer. It's usually a 4 years residence card, renewable, and we try to get those. So if you hear about European blue card or qualified employee status, it's the top visa categories currently available in France, and we always try when we do UK to France immigration, we try to go for this status. It's not always feasible, so it's if not, we have other categories like the intra-corporate transfer or classic work permits and visa application. So yeah, I would like to warn a bit our the all people here this morning because next year we will have the new for the presidential elections. And of course, the immigration topic will be highly debated, and maybe there will be a major immigration bill in the next year. So within Majoral, we are very cautious about that, and yes, we will send you some information through the chamber if there are some changes. And finally, for the next slide, I guess, as very quick risk in case of non-compliance. There are a full range of sanctions if you are not compliant in terms of immigration. So, of course, legal and criminal liability, but it can be also labor disputes before the French labor court. Financial penalties that have been increased. So, as you can see, it can be sometimes up to 20,000 euros per worker in case of illegal immigration situation, and reputational harm. And best practice, if you need to remember one word, is anticipating. Anticipating is a key because we can do whatever we need to do in coordination with my colleagues this morning. So yeah, I would like to emphasize this morning. Please monitor deadlines, not to be stressed, and that so we have the time to do each topic compliant. Thank you for your attention, and of course, I remain at your disposal for any questions.
Thank you, Clarisse. So,
Yeah. So, next slide. Yeah. Hello, everyone. I am David Spira. I'm a French chartered accountant and a statutory auditor, and I'm partner of Orial. Orial is an accounting firm based in Lyon and Paris with 20 partners and around 220 employees. I am delighted to be part of this presentation, and I'm going to focus this presentation on payroll and how it works in France. We have around 10 minutes, so I won't go into a lot of details, and I will try to focus this presentation on what needs to be remembered. So we're going to explain how it works, what it costs, what are the key risks, and give you some practical advice. Next slide. So why France feels different from the UK? First, you have in France higher employer contributions, and we're going to go into more details about that in the next slide. You have strong employee protections. You have employees benefit from health insurance, complementary health insurance, disability and death insurance, pension, complementary pension, family benefits, and also the employer contributes to apprenticeship tax, training levy, housing contribution. In France, you have more regulation, you have employment law, you have a collective bargaining agreements, and we're going to talk about that later on. And you also have laws related to social protection and social benefits. And you must also be aware that there is a highly structured monthly reporting for payroll, and we're going to address this matter in the next slides. So what is the real cost of an employee in France? So let's say you have an employee with a gross salary of 50,000 euros. The rate of the employee social contribution is around 20%. So the employee will pay 10,000 euros of employee social contribution. So he will get a net of 40,000 euros. And for the employer, on top of the gross salary of 50,000 euros, the employer social contributions is around 40%. So the employer will pay around 20,000 euros of employer social contribution. So The cost for the employer is around 70,000 euros, and the net for the employee is 40,000 euros. So this is an example, it's an estimate, but gives you an idea of the amount of social contributions paid. Next slide. Yeah. So what is the structure of a French payslip? It's a consequence of what we talked earlier. So you have the gross salary in a payslip, you have employee and employer social contributions, you have income tax withholding because the employee has to pay income tax and it's paid directly by the employer on the payslip, and you have the net pay. So this is a basic structure of the payslip, but you will get more information like paid vacation days, benefits in kinds, advance payments, and so on. What is the monthly payroll process? So when you have a contract with a payroll provider, you will have a process in place. The first step is to collect variable elements. So variable elements are things like bonuses, sick leave, paid vacation days, overtime, benefits in kinds, advance payments. Once the payroll provider has these variable elements, you will generate payslips. So payslips are prepared on a monthly basis. They have to be generated before group deadline, and they have to be approved, of course, by the clients. And once the payslips are generated, the payroll provider will submit DSN declarations, and it will trigger the payment of social contributions. Social contributions include URSSAF. URSSAF is the main social body in France, so it's a large part of the social contributions, but you also have pension as well, and complementary health insurance and disability and death insurance. URSSAF is paid for companies with a staff lower than 11 on a quarterly basis. Otherwise, it's paid on a monthly basis. Next slide. So what is the DSN? We were talking about the DSN on the previous slide. The DSN is in French, Déclaration sociale nominative. It's a monthly digital filing. It reports salaries and contributions. It triggers payments to social bodies, and it's mandatory. So you cannot prepare payslip without this reporting system. It includes salaries, contributions, employee data, and with the DSN, social bodies are paid, authorities are informed, URSSAF, but also the tax administrations, and pension rights are recorded. So it's an efficient system once it is put in place. So let's talk now about collective bargaining agreements. Collective bargaining agreements are agreed between trade unions and employers. They are often missed, so you have to be careful about it. Your industry determines which collective agreement applies, and it affects payroll calculations. It determines minimum salary, overtime rules, notice periods, and sick pay indemnity. So this is something you have to be careful about. You also have to be careful about employment law as well. Next slide. So let's wrap up. What are key risks for UK entrepreneurs regarding payslip? First, underestimating true cost, ignoring collective agreements, and also incorrect termination procedures. So termination is formal and regulated in France. You have to strictly respect the legal environment applicable to avoid traps and risks of paying higher indemnities to the employees. So you need to be assisted by an employment lawyer when you terminate an employment contract. Practical advice, so you have to estimate payroll costs precisely before starting. Use a French payroll provider. check collective agreements before hiring and plan exits carefully. Well, thank you very much for your attention.
So hello everyone. I apologize for my voice. The Easter break also got me. But anyway, we'll figure this out. So at MIA, we are a broker specialized in employee benefits. So after you figure out the registration of the company potentially, or you open a firm in France, or you already have a subsidiary in France employing people from the UK, or you actually are waiting to do so, you will go to payroll as David shows. This is something that must be done right after, and in the first place is something that is going to be extremely key for the rest of the obligations. And on top of the registration of the company, the hires and the payroll, the collective bargaining agreement, come a new obligation, and these are the mandatory insurance. And so you will see that in France, we are very strict in providing these obligations. And after these few marches are these steps are combined, you will see that the employer has the obligation to make sure employees are properly covered. They are obligations, obviously, if the people come from the UK and actually start working with a local French contract. And so therefore will apply to Social Security, and then we'll have to join the mandatory insurance of the company in France. And there are also possibilities to maneuver around somebody that will just come to France but not register to Social Security, or maybe be still seconded employees and so attached to the UK. So the next step after payroll is being set up and the collective bargaining agreement is chosen. We will then move on to seeing what the compulsory insurances are for the employees, whatever their status. So employee benefits in France is mainly two items. The first one is a group medical insurance. So when you have an entity in France, if you employ people from France, but also from abroad who actually qualify to Social Security, they will have to be enrolled under these plans. So medical insurance is something starting with one employee. So we do a group of one in France. We're very keen on providing that as of the first hire. And so basically this comes on top of Social Security as an extra a care that will reimburse most of the potential medical acts of the employees. This is something that is extremely comprehensive in France compared to maybe the UK or some other countries, because we have outpatient, inpatient, so hospitalization, current medicine, as well as dental, vision, preventive care. All of this is packaged under one same contract, and all members of staff need to be covered. We do have a bit still of this potential differentiation between cadre and non-cadre that can happen, but it's still on the market, but it's growing to be less and less market practice to make a difference between people. So we probably see more contracts that are for all members of staff in the past years. So that's compulsory by law, doesn't depend on the CBA, the collective bargaining agreement, but it actually is mandatory for any firm that has any employee in France employed under French payroll and have access to Social Security. We'll see if again later if the people don't have access to Social Security. Second is the life and disability, or death and disability. This is mainly for cadre employees. So if they are cadre, naturally they need by law a plan for this of coverage for life and disability. So we'll come back to the details of these plans. And then basically the collective bargaining agreements are going to basically be firm on minimum requirements that employers must follow. So you must have a certain level of lump sum in case of death of the employee, a certain education annuity potentially, a certain level of reimbursement for sick leave, these kinds of things. So these contracts are determined by mainly, again, if people employ cadre and if there are some collective bargaining agreements there. Then you have other benefits in France. We do see some new regulations on profit sharing passed last year in France. Mobility is something slightly different per se, meaning that if you have people coming from abroad and then returning, it's more business travel type of insurance, and we'll come back to seconded and expat employees. Yeah, so these are other items of benefits that we can pass on that are not mandatory at this stage. So these main benefits here, medical and life and disability, the very cautious, I mean, the employers must be cautious on a few things. One is that there is a usual cost share between the employer and the employee on these mandatory insurance. So the employer not only must provide something, but also has the obligation to participate up until a certain level. Most of the time for medical is going to be at least 50% of the employee cost, but we see on the market in France that most of the time the employers participate 50% of the family as well. It's very common. And then depending on the CBA can be more than 50%. So that is depends really on the collective bargaining agreement. So again, as David said, it's very important to look into the obligations in there. Obviously, as brokers at MIA, if by any means you come across the need to set up mandatory insurance, we'll be providing you the information of what the cost share is supposed to be, and then you can make a rightful decision in that sense. Same for life and disability. The cost share is usually divided into the slices of salary, because this is how the pay slips work in France. We have two different slices of salary, and so the cost of the group life insurance and disability insurance will be based on the employee's salary, and therefore the employer must participate towards that cost as well. So all these plans come again on top of Social Security. So we're still talking about either French employees or UK employees that come to France as expats, and so would qualify to be employed by the firm locally and have access to Social Security. Again, we'll come back to those who don't slightly later. So another obligation for French companies that dates back to last year mainly is a new change in companies that have 11 employees or more. We see that companies who have been making profit in the last 3 consecutive years must set up a scheme of profit sharing. And so these schemes of profit sharing, you may have heard of them. Some of them are famous on the market, like participation or intéressement. Abondement and prime Macron, so PPV, are the 4 different schemes. So that would be basically profit sharing bonus, performance-based bonus, matching contributions on savings plans, and the value sharing bonus, the prime Macron. So these are the 4 schemes that are the only ones that will basically qualify for the employer to be compliant with this regulation that was passed in 2025. Again, if the company has been making profit for the last 3 consecutive years, up to a certain point, a profit sharing scheme must be set up within the company, and that covers all members of staff. If you currently already as an employer are doing some bonuses, some incentives, and it's not participation, intéressement, abondement, or PPV, it's not going to work. You need one of these 4. This obligation, yet there's no penalty. So we like this in France, we set up a law and then we don't penalize anybody for not doing it. However, what we will see is that, again, with the election coming out next year, and the fact that it's been a test phase of type of a law at this stage, we consider that it may be penalized in the future for those who haven't played the game. And it became naturally market practice to do that, because most companies actually still try to do it, obviously, if it's mandatory. In certain cases, you will see that supplemental pension, which is not the CNAV, so not the Social Security pension, not the Agir Carco, which is the complementary pension and is deducted in most of the pay slips. We have another layer of pension that is called supplemental pension in France. It's before called Article 83, and now it's called PER obligatoire. PER is Plan d'épargne retraite in a sense. And this is mandatory in certain CBAs. So like a broker, for example, or insurance companies that open in France, employers must actually contribute an extra layer of salary to this type of pension. And this is an individual plan that is open for basically each employee, a bank account on which they contribute some salary and transform into an annuity when they retire and comes on top of the regular national scheme. And it's tax exempted to a certain extent and a great talent retainer at the same time. So some companies, considering our current system in France, being decreasing its impact, are actually considering supplemental pension, even though it's not mandatory. Last but not least, this is probably some of the most important slides for us today is that, so when you have somebody coming from the UK and so will qualify as an expat, for example, and so be employed by the French entity, they will qualify to the group plans. They will be employed locally, they will have French payroll, and they will have the obligations. And so the employer has the obligation to enroll them under the mandatory plans we've just seen. So the coverage starts as hire date. So the first day of hire, the plans must start for these employees. There are some exemptions that exist in the French law and that can be also determined by the company. But basically, under the French law and the collective bargaining agreement, the UK expats, if they come to France and are employed by the French entity, will qualify and need to be enrolled under these plans. So we may have also other possibilities as we saw. So we were talking about this with Clarisse and David. So if an employee is seconded, meaning they remain under UK payroll, potentially UK work contracts, obviously this is going to be different. The French local entities supposedly have no obligation in a sense. However, sometimes we see that from the UK, when the employee is seconded, they cannot qualify anymore maybe to the local UK plans because they travel, because they are not covered in France under the UK plans when they're on the French territory. So in this sense, the employer in France would naturally also look at potentially a solution to cover these employees, just because obviously duty of care here is important. You cannot just leave the employee on the French territory without qualifying to any potential care. So in a sense, we call this first euro or first pound in the sense of solutions, meaning we will have to qualify to a solution that doesn't come on top of Social Security, that will just be paying directly the employee's costs in medical, for example, if they are hospitalized or go to the doctor. So again, there are solutions from France to cover potentially an employee that comes to France to work and is not qualifying to Social Security. There is also the opportunity at times with specific insurers to cover employees that are doing back and forth. So they come to France a few days a week and then they come back to the UK. Maybe they're not covered properly in the UK because a seconded employee depends on what the UK firm has in place. There are also opportunities to develop the coverage and to also cover the UK as well as France at the same time. And so here, the obligation under life and disability is not the same, mainly because as a UK citizen and as a UK work contractor, there is no specific French law that says life and disability, which is mandatory for French people, should be also mandatory for UK seconded employees. So it really depends on what the company is willing to do. Do they want the UK national coming to France to work in France without Social Security to have a coverage of this kind or not, because they want to, make it homogeneous with the rest of the regular French or regular employees that qualify to the mandatory plans. So that really depends on each company. However, there are solutions for that. So whatever the situation of the employee, obviously as broker, we help finding out the right solution to make sure this is in line with the status of the employee. And if it's just small movements, meaning short-term assignments of 90 days or up to 180 days, and it's just missions as we call them, then in a sense, from the UK or from France, there are possibilities to cover what we would call business travel insurance, meaning that if something happens and hospitalization is needed, an accident, obviously they get covered and there is no upfront payments at the hospital to cover for the potential medical care that the employee would need. But this is more on a short-term assignment where the time spent in France is relatively low and shorter than a proper secondment or expatriation from the UK. Thank you. So on expat type plans, the solution will be basically what we would call IPMI. You will see that on the market. It's something that can be subscribed from anywhere in the world, actually. So I myself could be working with a US or UK insurer to cover a UK coming to France, or even French people going to the UK. So this is something that is, again, reimbursing the employee as of the first euro spent, and can be subscribed by the French entity, even though the UK worker is not at this stage within the frame of the work contract of the payroll of the company. So the French firm can subscribe a plan and then cover somebody from the UK coming to France with that. It doesn't need to be the UK company subscribing on behalf of the French entity. And same for life and disability. So most of the time, the main difference will be that there is medical underwriting, so medical questionnaire for these people that must subscribe to these plans. Whereas in France, we tend to neutralize the medical questionnaire in case of death and disability set up for the regular French employees with Social Security. So important. The pricing on all these mandatory insurance will depend mainly on the age of the population. That's something that is regular in most of these plans, where they are the mandatory ones or the expat types. And for the expat type plans, the country of destination, do we cover both countries at the same time? Is it short-term or long-term? All this will have an impact on the cost of the insurance.